Hi, this is Alan Gassman. I'm sorry we're starting a couple minutes late here. I'm here in the Gassman Studios with Colleen Flynn, a fantastic employment lawyer, and we're going to talk about hiring employees, 10 practical and legal strategies. Hold on to your hats. We've got about 29 and a half minutes. Colleen's going to earn her wages today and take you through this. Please join us next in a couple of weeks with Barry Flagg on New York Best Interest Rule for Life Insurance. Sri Kumar Rao is going to join us Tuesday, October 8th for Dealing with Challenges Ethically, Part 2, a really good presentation. I've got Jonathan Blotmacher joining us October 10th, the best estate planner in the United States and what he's thinking about, and a lot of other very interesting presentations that I hope you'll sign up for. But I don't want to take too much time from Colleen. Colleen is a fantastic employment lawyer. She has decades of experience. It doesn't look that way, but she does. She has a lot of experience. She does a fantastic job. She sincerely cares about what she does. She's really good defending employment claims. She's really good prosecuting employment claims. Hire her right away so you can conflict her out. You don't want her on either side when you're in a situation. She also gives great advice on practical situations with employees and independent contractors. Welcome, Colleen.
Thank you so much, Alan. I appreciate it.
We're going to talk today about something really important, and that's hiring employees and how crucial it is to do this in a proper manner, because we know how important it is to have really, really good, really happy, really effective employees. So Colleen's going to talk about not only the legal end of this, but how you get, as they say, the right people on the bus so that you can have a successful business or profession. Take it away, Colleen.
Thank you so much. So as we all know, we need employees to run our business. Not only is it the most expensive part, but probably the hardest part to get right, because if we don't have them, we don't have the right people, things are not going to go well. So we need to make certain that we are getting the right people in. And you probably know better than I do the right person, the right fit, the right skill set for the job. But what I can help you with is making certain that you are doing things legally and that we are not stepping in anything as we are walking through our recruitment process. And then once we have decided the person to whom we want to make the offer, making certain that we handle those things correctly and legally. And then their first day, getting everything in place to hopefully set a good tone for their employment with us, and so that they can be set up for success and that you can be set up for a successful hire. So the first thing that a business needs to decide is, what is their process going to be? And this is going to be different for every business, because you want to reach the people who have the skill set for your job. So, certain publications are not appropriate to advertise certain jobs, websites. Some of these websites now that have been around for a while, you can set your preferences. And so while I may be looking for a CEO for a company because of a couple of the keywords that are in the ad, I may get recreation directors or child care workers just because of the keywords that are set there and because of the electronic preferences of my resume going automatically when certain keywords sign up. So make certain that when you're putting things on electronic websites or message boards or all these popular websites, that you really are drilling down to what is your job description and what you're looking for and who are you looking for. Because if you make it very broad, you're going to get way more resumes than you want to be processing through, and chances are most of those people won't have the skill set that you're looking for the job. Some may be way overqualified, some may be way underqualified. So make certain that if you're going to use those, that you are honing in on that job description. Asking around, I know a lot of businesses are using LinkedIn these days to find candidates. So there's lots and lots of tools out there. Are you going to use a recruiter? And sometimes maybe that's more efficient. Obviously, that costs a little more money, but who's going to be doing that initial screening? So the first question, once you've gotten all these applications in and maybe you've made your list of folks you want to interview, is who's going to be doing the interviewing? Is it going to be your HR director doing a screening? Are you then going to let the managers ask the questions? What are you going to be doing? And so you want to have a good game plan. What questions are you going to ask? Who's going to ask them? One of the most important things is that we're asking the same questions to all the candidates for the same job. That helps us in several ways. One, because if we have those laid out ahead of time, it helps us really drill down on what are the questions that pertain to the job skills. And obviously those will vary from business to business and from position to position. But we want to make certain that we're getting the same information from all candidates. It also helps us prevent any types of discrimination claims down the road that, oh, they didn't ask me that because I fall into such and such category. So really think through ahead of time what the questions are going to be that you're going to ask. Lots of times I get, and what we're talking about now are verbal questions that we'll be asking during the interview. So lots of times I get, what should I ask? Or what's an illegal question? Or isn't it illegal to ask whatever? So the things we want to look at, what are appropriate questions? Appropriate questions are clarifying information that they may have submitted on either their job application or their resume. It says you worked for XYZ Manufacturing. What did you do there? Or I see you've had a big gap for 5 years of employment. What were you doing during that period? You want to be careful on some of those, but it's fair to ask, why were they out of the workplace? What were they doing to keep their skills up during that time? What skills did they gain during that time that would be applicable to this position? Things that relate to what's on the application, totally fair game. Again, or the resume. The thing I will tell you about resumes and applications, yes, resumes are great, but there is one little benefit to applications. At the bottom of the application, you can have a statement that says, I certify that all the information I'm providing is true and correct, and that would include any other information on any resume or any information I provide during the interview process. And then down the road, if we find out that the information on the resume or on the application is not accurate, we have a good basis for a termination because we said you submitted false information and a false certification. So I still do like job applications. They can write, see my resume, but I do like getting that certification that everything is full and accurate and I've answered everything honestly. Other appropriate questions would be questions that relate to the job that they're applying for. Ask them, what are their skills? How would you do X, Y, Z? How would you perform that job? How many times in your old job do you do that on a regular basis? Here's the thing. We all want to talk and we all want to sell our job to the applicant. And I want to sell to my next legal assistant why it's great to work at Johnson Post. But really at the end of the day, the applicant needs to be selling themselves to you and to explain to you why they have the skills to do your job and why they would be a good fit at your company, that their skills fit into what you're doing. Make certain you don't fall into the trap where you do all the talking and you try to sell your job to them. Because a lot of times they may be a great person, nice, you like them a lot, you want them to work there, but when they get there, they don't have the skills. So that's a trap that I have witnessed over the years in participating in interviews with lots of people. So we want to make certain we're asking similar questions, that really the same questions, but basically the same questions to all. You also want to ask questions to determine, are they really interested in this position? Is it a good fit for them? How does that work? Maintain the applications and the resume. Don't trash them. Don't throw them out. Our EEOC laws, Title VII, the ADA, and then we have state equivalents in Florida, the Florida Civil Rights Act. If somebody's going to bring a charge of discrimination, let's say they felt that they were discriminated in the hiring process or didn't get a job, they have up to a year to file that charge. So we don't want you to get rid of those, even if the person's not selected. More importantly, if you do select them, that should be maintained in their personnel file for the duration. So what are the inappropriate questions? People always say, oh, that's an illegal question. There's no illegal question. There's no law that says you can't ask it. However, the asking of the question may lead you to get information and that you are making a decision based on that you should not be considering in an employment decision. And what I mean by that is we cannot consider discriminatory characteristics listed in Title VII, age, race, religion, other things, disability, veteran status, marital status, national origin. We can't think of things like that and as a reason to or to not hire somebody. So that's why when you ask these questions, people think you're eliciting from them information that is going to have a bearing on your decision. So some of these things are age or date of birth. So on your job application, I see it all the time. What's your age? Not really an issue. The question may be, are you over 18? And And the reason you may need to ask if you're over 18 is because in states we have child labor laws. In Florida we have child labor laws. There's different laws for people who are under 18 versus over. So that's a fair question, in my opinion, because maybe our job would not fit in with those child labor laws that require certain breaks. They can't work certain hours. So fair question, but not what's your age. Doesn't really matter. What church do you attend? Religion is not should not be a factor in making a hiring decision. Maiden name, what's your maiden name? Because are we asking somebody what your marital status is? Are you married? I'll tell you my maiden name is Flynn, but I am married, so you may not even get that information, may not give you what you want in this day and age. Now, a lot of times people ask these questions inadvertently. Oh, you went to such and such high school, so did my spouse. What was your maiden name? Don't go there. You don't need to go there. If they're hired by you, you can chat about their high school days all you want then, but during the interview, not the right time. This should be a no-brainer. Are you pregnant, adopting, hosting, foster children, anything like that? Don't ask. Don't want you to ask about their number of children because, the perception is, oh, I have 6 kids. I may, kids get sick. I might call in sick. I might not be there. I may have to drive them to school. Here's a fair question. Can you work the hours of 8 to 6 p.m.? I don't care why your answer is yes or no. Just can you? Those are the hours of the job. Doesn't matter to me. You may have other hobbies, other interests, has nothing to do with children that prohibits you from working those hours of the job. So make certain you're not asking that. Arrests. Okay, so most of the time, arrests are not something to ask about. Convictions, criminal history, depending on what state you're in, certain things are fair game, but we want to stay away from arrests. Sexual orientation, no-brainer. Military service, unless you're a government entity and you're getting, you have to give credit for military service, that's a different situation. But general private employers should not ask about that, especially because we do have legal obligations to give leave to serve on, National Guard duty or if you're called up, so we don't want to ask about that. Also, unless it's a job requirement or goes to your job, we probably don't want to ask about foreign languages because that could be perceived as asking about what your national origin is. Now, however, if you're in Florida, we have a call center perhaps, and we have a lot of Spanish speaking or French speaking or people who speak a foreign language calling in, and we need those employees who speak that language, then that's a fair question. Disabilities. We don't ask people about their disabilities, unless they need an accommodation, which we need to give them an accommodation to even to apply, not just once they've been hired, but we do under the ADA have to give accommodations. And so, for instance, an accommodation may be giving somebody the application in advance if maybe they're low vision. And so the application you typically give them when they come in, but they need to have it ahead of time on their computer so that they can make it larger. That would be a reasonable accommodation, something like that. But we don't necessarily need to ask on the application what the disability is or verbally. Have you been injured on the job? We don't want to know. We don't know what their injuries are. Have you received work comp benefits? Same thing. Family medical issues, past addiction issues. None of those things are appropriate in either written or verbal form, so please don't ask those. Again, you're not going to get a lawsuit just because you asked it, but if you don't hire the person may perceive that they're not being hired because of that reason. So now you are thinking you like one of the candidates and you want to make them an offer. So what I would tell you is your safest bet is you want to make a conditional offer of employment, and you want to make it conditioned on passing the background check. And a lot of times in this day and age, people are just hiring companies to do these background checks. This is not your HR person is calling the references. That to me is different from when you are hiring a background check, and you have to decide what your business wants to do. Now, if you do a background check, it's covered under the Fair Credit Reporting Act. Even if you're not checking credit, even if you're just hiring one of the companies out there that does these to check the criminal records and whatever records are out there, public records. So they are doing that, you're hiring them to do that. Now, if your HR person is checking references and calling, different scenario, you don't have to follow the Fair Credit Reporting Act. But once you start using the background check companies, you have to follow the law. The law then requires you to get a release and a disclosure from the person before you do that background check. And Not to get too far in the weeds, but they do say that the release and the disclosure have to be standalone, and you can't put in there that, they won't sue you for anything that they find out because of this. These documents can only be the release and the disclosure. Once you get the information back, and let's say there's something terrible on there that you just can't hire them, let's say they just got out of jail for prison for burglary, and you are looking for a person to be the maintenance man or maintenance person, I should say, maintenance individual at an apartment complex, and they're going to have the master key to every unit there. Well, you probably don't want that because they've just, gotten out of prison for burglary. Probably not a good person to hire for that, because you also have an obligation to protect those tenants. So at that point, you're going to send out what's called a pre-adverse action letter, and the company you hired to do these checks should have these forms. If they don't, you can call me or somebody else, but most of these companies all know what they're doing. But you have to give them pre-adverse action and say, we've run your background check, here's a copy of the report, we're concerned about it. At that point, they then get time to come to you and say, that's not me, I've never been in prison, I didn't do anything like that, somebody must have my social security number, your background screening company must have run the wrong number, they must have transposed my numbers, whatever it is, you give them time to clear it up. If at the end of the period of time they have not cleared it up, you then take the actual adverse action and rescind the offer. Most of the times we never hear from the people. It is them. It's not something that they can cure. It's not something that they can adequately explain to you. And so therefore, you will then give them the adverse action letter.
Colleen, can I ask you a question on this? What about if you have your law firm check on LexisNexis and run a traditional detective report? You're not able to do that without consent of the potential employee?
Well, it depends, because if law firms can be considered consumer reporting agencies under the Fair Credit Reporting Act. So if the law firm's running it on behalf of somebody else and we're reporting it back to it, I believe that the law firm would be considered a credit reporting agency and subject to those laws. Now, if I own my own business and I want to check public records, I sit in Pinellas County, I'm just going to go online and run the public records search. That's a different scenario. However, you still need to be really careful when you're getting those records back, because we still have other state and federal laws that apply, and that would be what you can and cannot, and should not consider someone's background when you're disqualifying them for employment. We could talk for hours on that, but generally the EEOC guidance is that, if you're going to disqualify somebody from a criminal reason, it needs to be based on a conviction or a guilty plea or a no contest plea. It shouldn't be based on just the arrest, and that the crime has to be job related and consistent with business necessity. So the easiest example I can give is a receptionist at a law firm. We'd run the background check. He or she has a DUI in their background. Is that disqualifying? No, because they're not driving for my law firm. Now, I own a delivery company. They had a DUI 6 months ago. I'm never going to be able to get them insured under my insurance plan. That's probably disqualifying under those circumstances. So it's important that you analyze all the facts and that you are following the Fair Credit Reporting Act before you do run any background screening on these applicants. But like I said, you want to make certain you also don't do it until you give somebody an offer and you make the offer contingent on that. Same thing if you want to do drug screening. Give them a conditional offer, do the drug screening, and it's conditioned on passing. Sometimes we never hear from people again after we give them the letter saying, oh, great, we want to hire you, but we got to go do the drug check. They never go do it. We revoke the offer. And just keep in mind, I know most of us are probably sitting in Florida, but these laws do vary by state. There are some places that you can't ask about criminal convictions on the application, and those are the ban the box jurisdictions. Florida, we don't have those yet, but just keep an eye on that. And there's been a lot of litigation and EEOC movement on these background checks. So be careful when you're doing them. Not only do we have to follow the Fair Credit Reporting Act when we're hiring an outsider to do those for us, but when we get the results, we have to make certain that we're following the EEOC with respect to analyzing the results. So the next fun one is the Form I-9 that we are required to do for all new employees. Everybody hired has to fill out the I-9 on or before their first day of work. And But here's the caveat: you can't give it to them until you've made a conditional or an offer of employment. So you can't give it to everybody who comes in to interview for the job. But Section 1 of that form has to be filled out no later than the first day of employment. And number 2 has to be filled out by the employer within 3 business days of the employee's first day of employment. The current form is on the internet. In the top right-hand corner, there is an expiration date. You must use the form that's current at the time the employee fills it out. Now, this always happens. Right now, the form expired August 31, 2019. We don't have a new form yet, and they know that. There's a grace period, but don't pull your form that's just been in your files since 2010 and use that form, because at the top of that one, it probably has a 2013 expiration date. So make certain that you're using the current form. Also, as a caveat, there is a Spanish version of the form, but that can only be used in Puerto Rico by employers in Puerto Rico. So if you have a large Spanish-speaking population at your job, you may think it's easier for them to use the Spanish-speaking or the Spanish version of the form. Can't do that unless you're in Puerto Rico. You have to use a translator to help them fill out the form should an employee need it. So just some other general rules. You can't specify which documents they need to show you. As everybody probably knows, there's columns A, B, and C. You can bring me your passport. You can bring me your social security card and your license. You cannot tell people what they bring you. If they bring you forms that are in the list, you got to take them. But you have to make certain that they're good. If they don't look right, go online to the ICE website. It has a whole handbook, and it will show you what the proper documentation for each form looks like. So if you've never seen a permanent resident card before and someone gives it to you, rather than saying, do you have anything else? Do you have another form that would fit? I'm just not familiar with this. That would be illegal. You can go online and you hold up their card to what's on there, and then you'll see that, okay, this is fine. You don't re-verify U.S. citizens, even if they give you a document that's going to expire, like my passport expires in 10 years. I don't have to re-verify that. However, if somebody's on a work visa, you do need to re-verify that before it expires, because if it expires and they haven't gotten it extended, they can no longer work with you. Should you come into a company, find out there's a bunch of problems, you can correct it, go online, and they'll tell you how to do that, but that's important. You've got to retain the information, keep the photocopies. If you're going to photocopy the documents they give you, do it for everybody, not just for some people and not others. So now we've got somebody. We know that they're there. How are we going to pay them? We are going to determine whether they should be paid as an exempt employee on a salary basis, and we don't owe them overtime, or if they're going to be an employee who is non-exempt and gets paid overtime. So the easiest way, of course, is hourly basis, and then when they work more than 40 in a work week, they get paid time and a half. The harder one, and the one people need to be careful about, and let me go back a slide here, is, we're on the right slide, is if the position is exempt, you must compensate the employee on the salary basis, and it's an and test, they have to meet one of the exemptions. So one of the exemptions is the executive exemption, and I won't bore you with what it is, but that is somebody who is managing at least 2 or more of their full-time employees. They must be managing. They can't just be a shift leader or work alongside 2 or more. These are really, really people who manage as their job. We've got an administrative exemption, which is not administrative in the secretarial or paper and filing standpoint. These are performance of office or non-manual work related to the management of the business, and the person has a lot of discretion and independent judgment with respect to matters of significance. So that could be your HR director. They may not supervise people to get the executive exemption, but they're running your HR department. That might be a marketing director. People who have a lot of discretion within their area. Professional exemption, those are the doctors and the lawyers, knowledge in the field of science or learning with a prolonged specialized degree. So exempt employees have to get the full salary for any week in which they work any hours. So I could work an hour and then not work because we have a hurricane coming, let's say, but I still get my whole salary. So generally, I'm going to get my whole salary if I'm an exempt employee, whether I work 2 hours in the week or 85 hours in the week, and I'm going to get that same amount of money. So the employer gets the benefit when I work more than 40, and then I get the benefit when I work less. So the theory is that it works out. You cannot take any deductions from their pay. except for some specific reasons, which I have listed out here. So be careful that you are not deducting from exempt employees of pay. So next thing we have here are what are the record-keeping requirements that we need for employees that we have. First of all, there are posting requirements, and this is not under the Fair Labor Standards Act only. These are under various laws. We have posting requirements. We have FMLA requirements to post. We have Fair Labor Standards Act. Everybody has seen the work comp requirements. So make certain that you do have all the required postings in your break room, by the time clock, wherever. Let's see here. So we need to make certain that we are keeping our records for our non-exempt employees. They've got to give us their time cards, their time records. So you can have a punch clock, you could have it handwritten out, but what you want to have for these non-exempt folks is time in, time they went to lunch, time they came back from lunch, time out for the day, and that we're paying them on that. And remember, you can't deduct for those, breaks during the day of 15 minutes. You can only deduct for your half-hour meal breaks. We want to make certain that under the FLSA, we're keeping 3 years of payroll records and any of these time clock records. But I will tell you, even though that's the legal requirement, you need to keep them for much longer than that. 5 years is the Florida statute of limitations for minimum wage claims. You've got various IRS audits. You've got other reasons why you may need longer payroll records than 3 and 2 years. So please keep them as much as you can. All right, our next slide, let's see, are we going? No. Okay, so some of our next topics that I wanted to talk about are, let's see here, the employee's first day. So we get our person, they've shown up, they've passed all our background screens, and here they are, day one. What are we going to do with them? So we're going to have them go to HR, and they are going to fill out the required paperwork. They're going to fill out their W-4, their I-9. You're going to give them their employee handbook. You're going to get them to sign the receipt. Hopefully, we're going to have a probationary policy period, and we'll learn a little bit more about that next week when we talk about termination, why that's important. If there are benefits issues we need them to fill out the first day, depending on when they're eligible for your health insurance, things like that. Want to get that all filled out. Do you have confidentiality agreements that you need them to sign before they start seeing your confidential information? You need them to fill out those confidentiality agreements. If you require restrictive covenants, such as non-solicitations, we want to get those filled out right away too. So I also think that depending on, I just want to mention this, depending on if you're outside of Florida, restrictive covenants, there's lots of different laws. California basically can't have any. Florida is a bit more liberal. Some states require that you tell the person about it during the interview process in writing, that if they take this job, they're going to have to sign it. Other states like Florida, even if they've already been employed and you now want to institute a restrictive covenant, ongoing employment is sufficient consideration. But if you think that that is something that you want to have in place, make certain that you've talked with your counsel ahead of time to see if it's legal, and not only if it's legal, but how you want to communicate that will be a job requirement. But the most important thing is getting all these things filled out the first day right away before they have any access to your confidential information. And with that, I'm going to turn it over to any questions. I know there's a lot of information in 30 minutes, and always you can email me too, but if anybody has any questions or if Alan has any, I'd be happy to answer some.
So Colleen, having done this for many years now, what is the biggest difference you see between a client who has a successful hiring process, happy and good employees, much fewer problems than the norm, versus your clients who always seem to have problems with employees? What are the differences in the hiring process that make that happen?
I think really taking the time to interview the person and making certain that you probably are not hiring the first candidate that comes in the door, and seeing who else is out there and asking the right questions. The biggest thing I witness is people trying to sell the job versus listening to the candidate sell themselves to you. Because it's a human nature. We all want to talk about how great our workplace is and how great this job is, and here's what you would be doing, when we really want to be saying, what can you do for me? How can you fit in here? So that's really one of the biggest things I see. I think rushing, I think not that having that feeling of desperation, we got to get somebody in here. You really want to get the right person in there, because you get the wrong person in there, now you're going to terminate them, you're going to start over, it's a disruption, you're going to have spent time training them. So I think really making certain that you're hiring the right candidate and doing your due diligence.
Now, our law firm uses Omnia profiles, so we always run a psychological report on a candidate before we make the hire decision, and we use that significantly in the employment process. What are the legalities of that, and what are the pros and cons?
Sure. So there are lots of laws that talk about what tests you can and cannot do pre-hire, post-hire, post-offer, pre-hire. So you have to be careful. Medical exams, there's a whole body of case law on when those are and are not appropriate. Skills tests are always a good way to do something. Demonstrate to me that you can do this. Show me how you can do this. Skills tests are different under the law than tests that could be construed as medical tests. So to the extent that employers want to implement pre-hire testing as opposed to post-offer, and if there's any issue about whether it's a medical test versus a skills test or whether it could implicate both, you always want to talk to your lawyer about that. And be careful with those too, because those are kind of some of the hot button issues these days.
But IQ tests are not permitted, or they're possibly problematic?
Yeah, they're problematic, I would say. Let me say this. I have not looked into the law on IQ tests lately, and I will tell you the reason why is because I haven't had anybody use them lately in years and years and years. So I don't even haven't looked at that, but there have been a lot of situations where those have been deemed problematic by the court.
Okay, very good. All right, well, I think the most important message we have now is that Colleen will be back with us next week, September 26, 2019, on what's just as important, and that's terminating employees. Colleen, thank you so much for being with us today.
Thanks for having me.
And viewers, thanks for sticking out another program. We really appreciate it. Please join us. Please also make sure you put October 3rd on your calendar for Barry Flagg, October 8th for Sri Kumar Rao, October 10th for Jonathan Blotmacher, and many more conferences coming up. Thanks to the FICPA for having me speak on asset protection in Tampa, October 24th. That's asset protection for professionals. Everybody have a great day, and may the rest of your time be billable. Thank you.